Hello, good afternoon to you and you and you. Thank you for joining us today. It's 2 o'clock, another beautiful Sunday, Sunday the 15th of November 2020. On this program, we are discussing the Nigerian Constitution, understanding the rights of the Nigerian citizen, and this is part 4 today. Yay! So we've come a long way and we are excited about it. Why did I start this journey? With the NSAS protests that spiraled into one of the biggest, should I say, accountability campaigns ever that I've witnessed in my life in the country, Nigeria. With all the issues that happened, people wanting better governance, better accountability, better rights for the Nigerian citizens, I felt that it was imperative that we even know more about what the rights of the Nigerian citizen really are. So I reached out to Primary Africa Legal, one of the largest and most distinguished law firms across the Niger, and they were more than glad to partner with me. And we've had some spectacular lawyers with us for 4 weeks now. This is our 4th outing together. So allow me welcome up to join me on stage the beautiful, the distinguished gentlemen and lady who will be joining us soon. Here we have Nonso, who is also known as Mozart. Maria.
Hello, everyone. Welcome once again.
Thank you.
Hello, everyone. Good afternoon.
And Sarah, our special somebody, she will be joining us shortly. I think the network has just been funny. My name is Joyce Daniels, and I'm honored to have you here with me. We have been on this journey 4 weeks, and we have been discussing the Nigerian Constitution. It is an 8-chapter handbook, if you would allow me say. And okay, yeah, so special story is here with us now. Everyone, please say welcome to Sarah. Welcome, Sarah. She's here with us.
Welcome, Sarah.
Yeah, thank you. So, Sarah, please, if you don't mind, I might just ask you to please enlighten our viewers, those who are joining us on YouTube and on Facebook, and those who are watching the replay. Just let us into some of the things that we have discussed this past few weeks, if you might. Thank you.
Okay, thank you so much, Joyce. Welcome everyone to today's session. We have been discussing the Constitution, and we started by introducing the preamble, which firmly establishes the fact that we, the people, made this Constitution to guide us, to direct our affairs. And then we also went on to talk about the supremacy of the Constitution, the fact that it is binding on all persons, all authorities, as long as you're a Nigerian Constitution. The provisions of the Constitution is binding and has the effect of the law. We went on to talk about the various arms of government, the legislature, even though in minor details, and we were going to discuss further on it today as well. We talked about the fundamental principle and directive principles of state policies, which basically provides policies on which our government is to govern us. And we talked about the fundamental rights contained in Chapter 4 of the Constitution: your right to life, right to liberty, the right to dignity of human person, right to freedom of expression. All and all, we discussed all the fundamental rights in the Constitution. And then we also discussed the fact that these rights are not in themselves absolute. There are certain circumstances that may derogate from that right, but we'll also learn about it more today. We also talked about, so basically these are all that we have talked about in this week. And then we implore each and every one of us to go back and study the Constitution, because it is the tool that we need to take us on this journey that we so much desire. So today we're going to continue to talk about the executive arm of government. and the judiciary, and of course the other ancillary provisions in the Constitution. So that's it.
Thank you, Sarah. Thank you so much. I'm very excited about this, and people are saying welcome in the chat. Thank you, Bello. Thank you, Peju. Thank you, Onyeka. We see your chat. For those on Facebook, I'm so sorry I'm unable to see your chat for now, but I will log on to Facebook on one of my devices and I will be able to monitor what's going on there. I'm particularly interested in hearing more about the executive and the judiciary because I'm for the first time I myself and many other Nigerians are becoming more aware and saying really who gives power to who? Is it the executive that gives power to the judiciary or should the judiciary have power on its own? But well, we will know what the constitution says. Maria is starting off today with chapter 6. So let's welcome Maria while the rest of us go backstage. Welcome.
All right. Thank you, Joyce, once again. Thank you, everybody, for joining us on this our journey of discussing the Nigerian Constitution. This is the fourth series, as Joyce rightly mentioned earlier. So I'm starting off the conversation with a discussion on chapter 6 of the Constitution. That's the executive arm of the government. Now, if you recall last week, Sarah led us on a discussion with respect to the executive, with respect to the legislative arm of the government. And she informed us that this is the arm that makes laws for us as a people and as a nation. Now, the executive is the arm that implement those laws that are made by the legislature. So their function and responsibility is to implement policies and programs of government as an organ of the government. Now, you recall that we had a conversation or discussion on the three tiers of government. That's the federal government, the state government, and the local government, right? Now, each of these tiers of government had its own executive body that govern and regulate its own affairs. Now, let's start with the federal government as an executive arm of the government. The federal government has the president, who is the chief executive officer and also the commander-in-chief of the armed forces, as we all as we usually hear. Now, Section 131 of the Constitution make provision or provide the requirements, right, or the qualification of a Nigerian citizen to aspire or to qualify to occupy the office of the President of Nigeria. And the first and most important provision, of course, as we all know, is that you must be a Nigerian. Unless you are a Nigerian, you cannot aspire to be a President of Nigeria, of course. Now, we also know that he must attain a certain age, and by the fourth alteration that we mentioned in the first discussion, we say it has been reduced to the age of 35 instead of 40 that we usually have. So every Nigerian that have attained the age of 35 is qualified and competent to aspire to be a president of Nigeria if he meets other qualifications, right? Then he must be a member of political party and must be sponsored by the political party. This is really a very important issue that has been in the front burner in terms of discussion, whether there should be private citizens or private citizens should aspire without being members of political party to occupy public offices. And I think during the third alteration, there was a discussion whether they should allow private citizens to come in as private candidates without belonging or without coming through any political party or without being sponsored by any political party. And there are Nigerians or there are people who think our democracy have not matured to the level where we allow independent candidacy. So that did not scale through. So you must belong to a political party before you can aspire to be a president of Nigeria, right? Then you must be educated up to at least a school leaving certificate or its equivalent. We recently, during the 2019 election, had a lot of interpretation by the court on what is even that school living certificate or its equivalent. A lot of interpretation. If you have worked in the civil service for a certain number of years, if you can read and write, if you can, so a lot of interpretation with respect to that. And I think we have had several conversations on that, on what is the school living certificate or if it means or its equivalent with respect to that. Now, because this chapter has to do with the composition of the executive and how it should be run, right? What I will want to concentrate, what I will want to do is things that really we should need to know, or I think we need to know as citizens for us to improve the system and improve the way things are being run in our country, right? Now, I will just go straight to section, yes, I will just go to provision of section 138 of the Constitution. That's disqualification of a person occupying the office of the president from holding any other executive or paid employment in any capacity. The reason why I want to go into that is because I want us to interrogate it as citizens, to ask ourselves whether this particular provision of the Constitution has been complied with by the executive arm of the government or by the people occupying the office of the president in Nigeria. We have had a situation in 99 and up until 1999 up until 2005, when our president was doubling as the Minister of Petroleum Resources. We also had the same situation from 2015 again till today, where the president again doubled as the president and also the Minister of Petroleum Resources. Now, the question is, was there a violation of that provision that forbid or that disqualified the president from holding any other executive office or paid up employment in any capacity? This issue went to court in 2018, and the court pronouncement was to the fact that since the Constitution expressly used the word to hold any other executive office, it means the duty of day-to-day running of the affairs of that other executive office other than the office of the president. So the court was of the view that since the president or since a person occupying the office of the president was not in actual sense running the day-to-day affairs of the office of the Minister of Petroleum Resources, and there is a minister running that office, he did not violate the provision of that Constitution. Now, it's for us to ask ourselves as citizens whether this really is serving us as a people, whether this is really turning out to be in our interest as a nation or not, and we begin to interrogate it and ask ourselves what is the way forward, or whether we need to take it up again in court or in any other capacity as citizens under the Constitution, as the Constitution empowers us as citizens. So this is something that I may want us to interrogate as a people and ask ourselves whether it's really serving us, right? Now, another issue I will want to go into is the provision of section 140 of the Constitution. It provides that a person elected to the office of the president shall not begin to perform the function of the office until he has declared his assets, right, and liabilities as prescribed in the Constitution, right? And so the question I want to ask us is, we have seen a situation from the return of the Fourth Republic in 1999 to date, where elected officials fail to declare their assets and their liability, and at the end of the day, occupy public office after taking the oath of office. And the Constitution said they shall not, in fact, specifically the president shall not begin to perform the function of the office until he has declared his asset and liability. And because of the level of non-compliance, because of how pronounced the non-compliance has become, we tend as a people to celebrate elected officials when they declare their asset. Instead of it being a duty and a responsibility on them, we tend to celebrate them when they do it because we do not, it's become like an abnormal thing in our nation. So the question again is, what do we do as citizens? What do we do as people to ensure that elected officials comply with this provision of the Constitution? This provision specifically provides for the president. I will go to another provision that provides for the other elected officials and other appointed officials, of course, of even the federal executive or of the executive council of government. Now, I, as a person, think we as citizens has a moral and social duty to ensure that elected officials, those people we elect to occupy public office, comply and observe every provision of this Constitution. There are different ways of us enforcing or ensuring that those people comply and observe those provisions. So it's for us to begin to have some sort of consciousness in that and begin to ensure that we hold them accountable, we hold them responsible, and we ensure that they obey and follow every provision of the Constitution that is provided for them, right? Now, I will go to the provision of section 142 of the Constitution. That's the provision that provide for the nomination of the vice president, right? It provides in any election in which the provision of the foregoing part of chapter relate, a candidate for election to the office of the president shall not be deemed to be validly nominated unless he nominated another candidate as his vice president, and some other provisions, right? Now, the fact that you have been nominated as a Nigerian to vie for the office of the president, you are not qualified to be elected unless you nominate somebody to be your running mate as your vice president. The reason why I am emphasizing this provision is because of another provision that I want to go into subsequently. And maybe when I get there, I will just remind you of why I mentioned that provision, right? And in fact, I'm even there. That's the provision of Section 148 on the executive responsibility of ministers and the vice president. It says the president may, in his discretion, assign to the vice president or any minister of the government of the Federal Republic responsibility for any business of the government of the federation, including the administration of any department of government. Now, I feel really there is some sort of needs for improvement in respect of this provision. That's my own personal belief. And of course, I want us to interrogate it as citizens and as people to see whether really this is serving us, whether this is good for our democracy, or we need to improve it. He said the president may, in his discretion, assign to the vice president. I have a feeling that there is no clear-cut responsibility, there is no clear-cut function, there is no clear-cut duty that is assigned to the office of the vice president or that is assigned to the vice president. It is entirely at the discretion of the president to assign to the vice president some sort of responsibility and duties. So there is a feeling among Nigerians, of course, definitely not only me, that the office of the vice president is tend to be made just a ceremonial office without clear-cut responsibilities, but rather everything is at the discretion of the president to assign to him whether or not. So it tends to make the office of the vice president really a bit ineffective in terms of what we will have benefited from such office. I think as a citizen, or there are some sort of citizens that think this provision should be improved to be able to give clear-cut responsibility, clear-cut function and duties to the office of the vice president for us to be able to benefit from such occupant of office in terms of their capacity and what they can be able to offer to us as a people and as a nation, right? Now, another provision again that I want to go to is the provision of Section 149 of the Constitution that provides for declaration of asset and liability of ministers before they take out of office. Just as I mentioned for the office of the president, the Constitution provides in Section 149, the ministers of government of the federation shall not enter upon the duties of his office unless he has declared his asset and liability as prescribed in this Constitution and has subsequently taken and subscribed to oath of allegiance and oath for the due execution of the duties of his office prescribed in the 7th schedule of this Constitution. Again, it goes back to what I mentioned earlier. We see a situation whereby appointees of the president, ministers, went on to occupy public office without them declaring their asset and liability, and there hasn't been any consequences for such violation of the act of the Constitution. Now, we need as a citizen to begin to again to interrogate this, to begin to ask questions. Why shouldn't the ministers of the federal or the Federal Executive Council comply with the provision of Section 149 of the Constitution before they went on or before they go on to occupy that office in Nigeria? It is a necessary requirement. The Constitution anticipates that this is necessary for us to be able to have a system that is clean, a system that is free of corruption and corrupt practices. And I think we need to enforce this. We need to ensure that this is all complied with by appointees of the president at every point in time in our democracy, right? Now, I will go to Section 152, which is also on asset declaration for special advisors of the president. Now, something that is really so surprising that you may find is the Constitution did not leave anything to chance. It provides for the president alone specifically. It went on to provide for his ministers in Section 149 specifically, and went down to even assistant or advisors of the president. So the question we need to ask ourselves is, if the Constitution can, or the drafters of the Constitution can take their time to make elaborate provisions for each and every occupant of a political office or each and every occupant of public office in Nigeria, why shouldn't we ensure the enforcement of this provision to ensure that people who occupy those offices comply and obey those provisions before they go on to occupy those offices? And even if they violate them, or in the event of violation of those provisions, we should ensure that as citizens, we hold those occupants of offices accountable and responsible for such kind of violations. Okay, I can see Joyce. I see Joyce coming.
Maria.
Hello, Joyce. Yes.
Yes, can you hear me?
I can hear you.
I'm frozen here. Wait,
Hello.
somewhat you've been saying things that have just been baffling me, and I just couldn't hold myself back. And I'm seeing comments flowing in the on YouTube. Can you hear me? Let me know, please, if you can hear me.
I can hear you. I'm with you.
And I'm just wondering, oh my gosh. So, besides of the citizens, who else is supposed to keep the government accountable? You are saying that the government itself, people who have been taking office over and over, well, you're not stipulating something that is hidden. We are agreeing with you that these provisions have been violated again and again. Who is supposed to keep them accountable? Who are the custodians of this law?
Okay. Right. Now, I will just answer specifically with respect to that act of violation that you mentioned, with respect to the declaration of asset. Are you with me? Can you hear me, Joyce?
Yes, please. I can hear you loud and clear.
Okay. The Constitution established a court that is called Court of Conduct Tribunal, and it also established a commission or an agency that is called Court of Conduct Bureau, right? This is the body, or these are the bodies that are mandated with the responsibility of ensuring that every occupant of public office in Nigeria declare his assets in accordance with the requirement or as prescribed by the Constitution, right? Now, the Court of Conduct Bureau has the duty of ensuring that every citizen or every occupant of public office declare his asset in a liability in accordance with the procedure or in accordance with the process that is prescribed by the Constitution. Now, if there is violation of that provision, the Code of Conduct Bureau has a duty to investigate such act of violation. And where the occupant of such public office is found to have violated that particular provision, such an occupant is to be charged to a court or to be charged to a tribunal that is called the Court of Conduct Tribunal and be tried in accordance with the laws of Nigeria, right? And if he is found to have violated that provision, the court will punish and sentence and punish him in accordance with the laws. Now, what we have seen over the years is a situation where both the Court of Conduct Bureau and the Court of, I will not even go to the Court of Conduct Tribunal, the Court of Conduct Bureau, I can say, fell in those responsibilities. That's what we keep seeing. Really, do you see public servant or public occupant of public office, particularly political office holders, complying with those provisions of the Constitution? And you also do not see the Court of Conduct Bureau going after those occupants of public offices because of those acts of violation. So because nobody goes after them, the whole issue is now just swept under the carpet and nobody questioned them. So what I'm saying is this: if those institutions fail to exercise or fail to perform their responsibilities or duties, that's the Code of Conduct Bureau, then we as citizens should now also begin to ask questions, should now also begin to hold our elected representative and elected public office holders responsible, because the Constitution has placed on us some sort of duties. Don't forget, when we were discussing the fundamental objectives and directive principles, right? We talked about the media being the watchdog, right? We also talked about in the fundamental right, our right to freedom of expression and peaceful assembly, right? The Constitution also empowers us as citizens to also mandate our legislators for members of the occupant of the executive. If we do think there are things that the members of the executive are not doing, our representative, elected representative at the National Assembly, has the duty of calling those executive members to order through different means. They have different powers. So we also need to begin to awaken our representative at the National Assembly level to ask them to exercise those powers that are conferred on them to begin to checkmate and question the occupant of the executive office with respect to such violation. Then on our part, we can also question the occupant, or we can begin to interrogate the occupant of the legislative office in our capacity as citizens, because we have different powers. We have the powers to even recall them to come back from those offices as citizens. So these are things that we should begin to do as citizens consciously. Maybe there may be some sort of compliance after if you take those steps, right? So I don't know if that answers some of the questions. Hello, Joyce, are you with me?
Yes, Maria, thank you very much. You can hear me now?
I can hear you.
All right, thank
you.
So
let me
answered my question and many of the questions of the others. Yes, please go ahead.
Okay, so let me just go to the provision of Section 158 of the Constitution. Section 158 of the Constitution provides for certain agencies or organs of the executive that the Constitution or the drafters of the Constitution knows to be very important organization. In fact, they are called pillars of our democracy, and that's what is obtainable in every democratic dispensation everywhere. There should be some sort of organs, or there should be some sort of agencies or organizations that should be strengthened and be made independent for our democracy to be strengthened, for our democracy to be strong. The Constitution in Section 150 or Section 158 provide for the independence of those organizations. It provides for the Code of Conduct Bureau. Remember, I just mentioned Code of Conduct Bureau. So the Constitution anticipates that the Code of Conduct Bureau is a very important agency of government to checkmate the occupant of public office or the occupant of political office in terms of asset declaration. That's why it makes it an independent organization or an independent organ of the government. It makes the National Judicial Council an independent organization. And so we'll discuss the National Judicial Council when he's discussing judiciary, I believe. The Federal Civil Service Commission, the Federal Judicial Service Commission, the Revenue Mobilization and Fiscal Commission, very important. And then the Federal Character Commission and the Independent National Electoral Commission. So those 7 or 6 organizations or those 7 agencies have been made independent by the Constitution, so that there shouldn't be any interference or any influence in their operations, in the exercise of their functions as prescribed by the Constitution, for them to be able to function independently, for our democracy to be strong, and for it to be matured to the level we ordinarily expect and want it to be, right? And this is, of course, not far-fetched. We already said it, because our democracy needs to be strong, and the only way that democracy can be strong, we need some sort of agencies to be the pillars of that democracy. And these are the agencies that should be strong for our democracy to be matured to the level we want it, right? Now, I will just mention the provision of Section 174 on the prosecution powers. The Office of the Attorney General of the Federation and the Minister of Justice is established by that provision. And the Attorney General of the Federation is presumed to be the chief law officer of the Federation. So he has the powers of prosecuting offenses that are prescribed under certain laws in Nigeria, right? So I think I will just leave that as it is. Now I will just go to again the provision of Section 175 that confer powers of the president to grant pardon, right, on what is called prerogative of mercy on people who have been convicted and found guilty by a court of law. So if a person is convicted and found guilty, the president, in exercise of his power, can subsequently pardon such a person for the offense and then grant him what is called a prerogative of mercy. Now let me go to the state executive. That's part 2 of chapter 6, right? Now, the provision of Section 176 and 177 provide for the office of governor of a state, and the governor of the state is the chief executive officer of that state. Just as the president is the chief executive officer of the president, the governor of the state is the chief executive officer of every state. And of course, definitely Section 177 provides for qualifications of every Nigerian to be a governor of his or her own state. And as we always say, the first and most important thing is you should be a Nigerian, of course. If you are not, then it's not possible. Yes. Then he must attain the age of 55, which we have already said it was 40. Now it is reduced to 35. Then he must be a member of political party. He must have been educated to at least a school certificate level or its equivalent, as we earlier mentioned. Now, the same provisions that relate to issues of asset declaration on the president, the ministers, and his advisors, the same provision also apply to the governor of the state. The provision of Section 183 also provide that also disqualify a governor of a state from holding any other office or any other executive office or period of employment, just as the president is prohibited from doing the same thing, right? And I earlier mentioned to you that this issue has gone to court in 2018, and the court has an interpretation with respect to it. Now, the provision of Section 185 provide or mandate a governor of a state to declare his asset and liability and take out of office before he assumes that office. So just as I mentioned while discussing the Federal Executive Council or the executive body at the federal level or at the central level, the same thing applies to the executive body or the executive governor of every state in Nigeria. He has a duty and he has a responsibility to declare his asset and liability before assuming office, right? Now, this issue of asset declaration is either the person did not declare or the person under declare, right? The issue of under declaration come where the person declares certain asset and omit or refuse to declare some other assets. So it is not to declare part and leave part, and these are another issues that we keep seeing in the in our democratic system, where public office holders tend to declare certain assets and leave out some other assets. The fact that you declare 2-3 assets and you leave 2-3 assets, another 10 assets or 11 assets, it is still a contravention of the provision of the Constitution. So it's a declaration of every asset and liability before you assume public office in Nigeria. Then the same thing apply to commissioners of every governor in the state, right? The provision of Section 194 of the Constitution mandates the commissioners of every state to declare their asset and liability before they go on to assume public office. Then the provision of Section 96, subsection 4 also mandates the advisors of every state governor to declare their asset and liability before they go on to assume public office, right? So I'm just going through the German provision that I think we need to know as citizens, that we need to interrogate as citizens, so that we do not take a long time discussing things that maybe are not really very germane to us as citizens. So I think I will stop here, and if there are questions, I would be very happy to take them. If there are areas of clarification, I will be very happy to clarify before I call it a wrap with respect to the chapter 6. Hello, Joyce.
I don't know what challenge I've been struggling with here with the internet. Can you hear me? Or can you see me?
I can hear you. I'm with you. I can. It's hanged.
Fantastic.
It's not moving.
So much. Thank you. The questions that came up before now, I believe you have answered most of them. There were questions and there were comments, and for some reason, my entire system is just freezing, so I'm not even able to scroll through those questions. I know that somebody made a comment that our ignorance has been our greatest bane. So since we have not known the law, we've also not known how to hold our leaders accountable. With the power of our voices, with the power of social media, I believe this is so enlightening to us. We're going to keep this information spread, or what's the English I'm trying to use? We're going to keep spreading this information. We're going to create memes. We're going to create short pictures, and hopefully we'll see people create skits, have short videos, and spread, letting people know what our rights are and what our rights are, what we are owed. I will like to just make a point about this asset declaration matter, because one of the biggest challenges we've had with public office holders is the accumulation of wealth that happens whilst in office. I believe that's the reason why they are asked to declare assets before coming into office. Is that true?
Exactly. There is nothing more than that. So that you should Nigerians should be able to know what you have before you occupy the office. And even after, while leaving the office, you will still have to declare so that we can know what you have acquired while in the office again.
Exactly my point. So we need to hold people accountable to that. Onyeka is asking a question here that says, does the state governor also have discretion over the roles and responsibilities of the deputy governor?
Exactly, it's the same thing. Let me point out to the particular section. Okay, responsibilities, executive responsibility of deputy governor and governor. It said the governor of a state may, in his discretion, right, assign to the deputy governor or any commissioner of the government of the state responsibility of any business for the government of the state. That's section 193 of the Constitution. So it's still the same thing as it is with the central government or executive body at the central government. It is still the same problem we are having at the state level, where every responsibility, duties, or function to be performed by the deputy governor is at the discretion of the governor of the state.
Fantastic. So it means that if we're asking for an adjustment, an amendment, or a rewriting, there should be right there in the Constitution, clear-cut duties of the deputy governor. I believe I'm picking the minds of all of us.
That's what I feel.
So we know what we should advocate for going forward. Thank you so much. I'm going to bring Nonso up to continue the discussion. Everyone in the comment section where you are, please say thank you to Maria. We're going to see him later. Should we have more questions, remember, beyond today, next week is going to be an open house by the grace of God. We will have other seasoned lawyers or seasoned constitutional lawyers join us, and we will talk about the way forward. What can we now do going forward? Nonso, welcome. Maria, thank you so much. Nonso, for some reason we can't hear you. If you can hear me, we can't hear you. I haven't heard you yet. Yes, it's better.
Can you hear me now?
Try with the earpiece again. Please try with the earpiece one more time.
All right. How about now? Can you hear me?
Yes, we can hear you. Thank you very much. Thank you.
All right. Okay, so we are going to continue our discussion with the Judicial Arm of Government. And like I said before, the fact that we always discuss it last, even on our discussion in the first class, does not mean that they are the least arm of government. You know, they say the last but not the least. But what the structure was trying to follow is to see the way we govern ourselves and the way government to government relates. That's the legislature, which Sarah discussed quickly at the last class. We have to enact these laws, deriving power from the Constitution, enacting laws that are consistent with the Constitution, and then the executive will have to implement these laws, and they have the full duties of implementation. And the Judicial Arm of Government will come in to interpret where need be. And we will all agree that there have been a lot of opportunities to interpret the Constitution, both in relations between government and relation between government and its citizen. So chapter 7 of the Constitution is in two parts. The first part talks about the federal courts, and the second part talks about the state courts. And it starts that discussion looking at the hierarchy of courts. And if we are discussing chapter 7, we will also discuss it in line with the third alteration of the Constitution, which altered part of part 1 to make accommodation for the National Industrial Courts, which will look into labor matters. So the highest court of our land is the Supreme Court, as the name sounds. The Supreme Court stands supreme and is the highest court of the land. It's the apex court of Nigeria, and which also implies that each jurisdiction is the highest in Nigeria. And the saying goes that if you lose out in the Supreme Court, your appeal may now start going to God, if such a route of appeal exists. Okay, so the Supreme Court exists as the apex court of the land and comprises, by virtue of Constitution, allows the Supreme Court to have about 21 justices. With the recent 8 justices of Supreme Court that were appointed, ratified, that were nominated, I will discuss this in detail later, nominated, appointed, and rectified by recently, we now have, luckily enough, 27 justices of Supreme Court, including the Chief Justice of Nigeria. It's a recent news, but it's a welcome development because it is going to help a lot of cases to move faster in that court. What has happened all this while is that because of the numerous number of cases that come to the court and the very few justices that were serving, it wasn't very easy to dispense with cases in record time, especially those cases where there are no specific provision for time limit, like the election-based cases. So we are hoping that with this increment in number, there will be some progress in that regard. So many other appeals that are in the Supreme Court will receive opportunities of hearing. So by virtue of the provision of the Constitution, the court has jurisdiction to the exclusion of any other court to receive appeal from the Court of Appeal. If there is one thing that they enjoy alone, it's only the Supreme Court that can hear appeal from the Court of Appeal. And they also exercise certain original jurisdiction to determine disputes between a state and another state, and the state and the Federal Republic of Nigeria by further amendments, by further laws that the National Assembly made. The Supreme Court is now able to take appeals between the one arm of the government, between the Senate, between the National Assembly and any executive arm of government. The qualification to become a Supreme Court justice is that you must have been in qualified practice of law in Nigeria, and so qualified for 15 years. And service in Supreme Court is up to 70 years old. So if you keep hearing that justices are retiring, maybe they are retiring by age. Perhaps another interesting thing is that there's also provisions to remove a justice of Supreme Court even before the retirement age. That will something that we see very much in the checks and balances that exist between relationship between one government arm and the other. The constitution that we give to ourselves was quite interesting, that it enables each arm of government to find a way to have that checks and balances on the other arm, so that the executive, although it may seem that they are so powerful, they have a lot of limits and checks and balances, in the sense that for certain offenses, for certain infractions, sorry, I don't choose to call it offenses because of immunities that the president and the governor holds, there will be grants for impeachment. And in the same way, there are grants for recall, and in the same way, there are grants for removal of a serving justice of the Supreme Court. I will come back to some controversial issues on that area as I run down. The next court is the Court of Appeal. Okay, it's the Court of Appeal and the Supreme Court could be said to be the two courts that serve the entire federation of Nigeria, in the sense that they deal with both matters that affect the Federal Republic of Nigeria, the federal government, and the state government. And when you now come and see that the other specialized courts have specific issues that they deal with, but the Court of Appeal comes next in the hierarchy, and it's like also a confluence court whereby it receives appeal from a lot of other trial courts that are below it, such as the Federal High Court, the National Industrial Court, the High Court of a State. For lawyers, the legal practitioners, the disciplinary committee. I think for the accountants as well, the ICANN Tribunal and the military court martial. So it's like a confluence court, which people say, in order for us to have a little bit of a fair chance of looking at issues before they go straight to the Supreme Court with finality. They come to the Court of Appeal. And also the Court of Appeal has that original jurisdiction to determine questions concerning whether a president or vice president have been validly elected. Before now, it used to have final jurisdiction to determine whether a governor had been duly elected, but that was changed later on. And also recently, it used to have jurisdiction to determine issues concerning labor law with finality. That was also changed recently. That we are now back to where a case on labor issues will now progress up to Supreme Courts. Okay, so the Constitution initially provided that for 49 justices, but that has later been amended to as high as 90 justices. And then they are appointed by the president, they being federal judges, on the recommendation of the National Judicial Council. We'll talk about National Judicial Council later, and subject to the confirmation by the Senate. And then the justices also must possess certain qualifications in order to give them the opportunity to determine the myriad of issues that they are supposed to determine. The next court in the hierarchy is the Federal High Court. Okay. Well, it's also the creation of the Constitution. And the interesting thing about the Federal High Court is that the Constitution tries to list out in details issues that the Federal High Court will have exclusive jurisdiction to entertain. And it's important to also seek professional assistance to help us to know whether our matters, our claims fall within the jurisdiction that the Federal High Court can entertain, because it may give us opportunity of going to the court and we will not be able to ventilate our grievances. In recent past, the Federal High Court have made a lot of effort to have a lot of judicial divisions, almost in all 36 states of the Federation. And then the other thing that I didn't discuss, which is not important, is why the Supreme Court and the Court of Appeal sit in panel. The Federal High Court, of course, presided by a single judge. The next federal court we need to talk about is the National Industrial Court, okay, which is established to determine also labor issues concerning employer and employee, concerning trade unions and employment relations. And that is a specialized court because we all are aware that the judicial arm, judicial branch of Nigeria's government consists of both the Supreme Court, other courts, and other specialized courts, one of which is National Industrial Courts, which exists to take in labor matters. And so it has given opportunity in recent times for them to have the constitutional backing to determine issues before them. Long before the third alteration, they've been that conversation whether they were superior court of record, even when they were created by act of the National Assembly, which, as we have seen in our discussion in chapter 1, the National Assembly, in addition to the court listed, can, by virtue of the act of the National Assembly, creates such other courts that may be important. Another court that the federal government of Nigeria takes care of, it's the High Court of the Federal Capital Territory, which we'll discuss a little bit more when we're discussing the state high courts, but the jurisdiction that state high courts exercises for the various, each of the 36 states of the Federation, the High Court of the Federal Capital Territory exercises for the Federal Capital Territory, which Stella will discuss a little bit more in the next session. But because the Federal Capital Territory jurisdiction issues that happen in the Federal Capital Territory are exercised by the federal government of Nigeria, therefore the creation of that court is also administered at that level, so that the appointment is also made by the President of the Federal Republic of Nigeria, just as other justices of the National Industrial Court, the Federal High Court, the Court of Appeal, and the Supreme Courts. We now come to state courts. There are other courts we may also see later, but let us quickly go into state courts, which we have at the top of it is the state high courts. Okay, jurisdiction for it is provided in the Constitution as well, and it's a court that is seen to have unlimited jurisdiction. Okay, subject to those exclusive items that the Constitution allows some other specialized court to determine. The jurisdiction of the state high court is said to be unlimited. Beforehand, before the area of having specialized courts with exclusive jurisdiction, state high court have been said to be that beast of burden that determines a whole lot of issues that may crop up. So we now see that with the creation of with the coming into effect of the federal high courts and now the national industrial courts, save for those matters that these two courts will determine, the state high courts has unlimited jurisdiction to determine matters that appear before it. We also have the Sharia Court of Appeals and the Customary Court of Appeal of various states as well as the Federal Capital Territory. Okay, just as their name specify, it's also part of the specialized courts that we have, because the Sharia Court of Appeal will determine matters involving Sharia law, especially in the states in the northern part of Nigeria, and is headed by a Grand Cadi and with a particular number of Cadis. It's also recognized by the Nigerian Constitution. In the same vein, the Customary Courts is also a court that has original jurisdiction, that has no original jurisdiction as the name implies, but has appellate jurisdiction to entertain appeals that extend from district courts, that extend from other courts that come and deals with customary issues, customary courts and other local courts. The customary court is headed by the president, who is also the head or admin head of the courts, and is also supported by other justices of the Customary Court of Appeal. So these two courts also have jurisdiction in the Federal Capital Territory, administered by the federal government of Nigeria. The other state court we need to look at is the Magistrate Courts and District Courts. Okay, though not prescribed under the 1999 Constitution, is almost one of the commonest courts that we know, because of its spread and a lot of matters that it determines. Though not mentioned in the 1999 Constitution, but it is recognized because the Constitution gives the state houses of assembly the powers to create, to make laws that can create such other courts, and in exercise of this power, or to rectifying this power, it's where the magistrate court finds its jurisdiction to entertain a lot of matters as the various state laws may prescribe for it to entertain. In northern parts of the country, it's also known as the district courts. And so the magistrate court help a great deal, because in the administration of criminal justice in this country, the magistrate court plays quite an invaluable role. And in recent times, because of the small claims regime that the Lagos state government adopted or enacted some procedure, the magistrate court have now been able to have that jurisdiction to quickly and immediately deal with certain small claims, and in an easy way. And it's been expected that other states will also take a cue, so that for citizens who will not have the opportunity or will not have the resources to go through the a little bit more concrete and a little formal, very formal procedures in other high courts, the magistrate court is supposed to have that summary jurisdiction and is supposed to be able to condescend to the level of looking at assisting the informal sectors, such informal sectors of our economy, which is what informed the creation of the small claims regime and other jurisdiction that the magistrate court do exercise. And it's important to also highlight that there are other tribunals, because if we look at the judicial powers that are created. And even when Sarah was discussing fundamental rights, we see that that right to fair hearing is not only when one is before a court. Adeton Miwa has asked, why do we have Sharia laws and courts in Nigeria if Nigeria is not a religious federation? I think we an interesting question which we also looked at initially when we discussed the fact that the Constitutional Provisional Section 10 does not allow us to have a religion. So it's what the Constitution has come to accommodate, but that doesn't mean that a particular religion has been adopted for the entire federation. Nigeria still remains a state that does not adopt a state's religion. Okay, by virtue of the fact that Constitution recognizes the power of various state houses of assembly to make laws, a good number of states in the northern part of Nigeria have come to reenact these laws as part of their state laws. And so it may be interesting to look at them as laws governing these various states, other than the fact that a Sharia regime has been brought into Nigeria, have been imposed on us in Nigeria. No, what really happened is that because of the peculiar socio-economic background, socio-cultural background of these states, they have come to say that, well, it would be nice for us to regulate along this line. And so they have gone ahead to enact laws to recognize those Sharia provision. Is the Sharia court only subject to state level? And does the Supreme Court have precedent over this court? Yes, the Supreme, even the Court of Appeal hears appeal from the Sharia Court of Appeal. And if the persons, if the parties are further not satisfied, there is also opportunity to appeal to the Supreme Court, which can decide with finality. And that is why in appointing justice of the Supreme Court, which thank you, nice I mentioned it, all these courts, as we've seen so far, down to the distance, they have the opportunity to be elevated, down to the Court of Appeal, down to the Supreme Court. And it is so designed by founders, we the framers of our Constitution, to see that even at that stage, we give opportunity for certain Sharia judges to also come to the Supreme Court to enable them, to enable us have the opportunity of people who are skilled in this specialized area of laws to be able to decide and sit in panel and give decisions on issues of Sharia law. So yes, the Supreme Court, the Court of Appeal, first of all, would have the right to receive appeal from Sharia Court of Appeal and be able to review if necessary. We have certain electoral tribunals, and my discussion there was that the Constitution also envisages the fact that even the right to fair hearing will go beyond the courts, as properly so called. So that right to fair hearing has an expansive definition that's not just court, even tribunals. And discussion also has it that even tribunals that were set up in our places of work, such principles of fair hearing will always be expected to be respected by these tribunals. So we have a Presidential Election Tribunal, as the name implies, which hears matters concerning whether someone is validly elected as president or vice president of the Federal Republic of Nigeria. Is the Court of Appeal, like I said, that has this jurisdiction to sit originally to hear this matter. We have the National Assembly Election Tribunal, which, as the name implies, decide matters concerning whether someone has been validly elected as a member of the National Assembly, whether the Senate or the House of Representatives. We also have the Governor and Legislative Electoral Tribunal, which handles matters concerning whether one has been validly elected as the governor or deputy governor of a state, as well as whether one has been validly elected as a member of the House of Assembly of a state. And of course, decisions which by this tribunal is appealable to the next courts, where it is the Presidential Electoral Tribunal which the Court of Appeal Justice, which comprises of judges of the Court of Appeal. Of course, the appeal will go to the Supreme Court, and Supreme Court to decide with finality. For the rest, which we are made up of panel, which a good number of them are judges. Of course, they need to go first to the Court of Appeal and then finally to the Supreme Court when it has to do with governor and deputy governor. We also have a Code of Conduct Tribunal, which also exercises certain judicial powers, just like Mawia discussed, that the Code of Conduct Bureau exists to help us checkmate our public officers to ensure that they stay focused to the directive principles that we have expected the state to continue to uphold instead of going there for their personal gains. And so where the Code of Conduct Bureau finds any of them wanting, we have the opportunity of seeing a case in the Code of Conduct Tribunal. And the Code of Conduct Tribunal has that powers to determine such issues that are brought before it. The term of the office of the chairman of the Code of Conduct Tribunal expires at the age of 70, and the judgment of the Code of Conduct Tribunal can only be appealed to the Court of Appeal, which of course we can see brings them almost to the level of a high court. And then the chairman and other members of the tribunal are appointed by the president on the recommendation of the National Judicial Council. This National Judicial Council that we'll be mentioning again and again, and important that we look at it, it's as the name implies, it exists to help with as an organ of the government to help in looking at qualifications, looking at the conduct of the members that occupy the judicial arm of government. We will notice from the discussion between Sarah and Muawiyah that in discussing modes of entry into this judicial arm of government, we didn't see anything like election, which is mainly based on appointments. So because of that, a lot of trusts is expected, and a lot of independence is expected, so that they don't at a point remain at the whims and caprices of the person that has appointed them. Take a good example of appointment of a federal judge. You will see that the National Judicial Council exists to be able to look at qualifications, look at people. Sometimes they walk through the Federal Judicial Service Commission or State Judicial Service Commission to look at suitable qualified persons, nominate them to the person who we appoint. And after the appointment of such persons, if it's the Supreme Court Justice, for instance, the Senate, we have to have that exclusive duty to rectify that appointment, and then they will now be sworn in. What it shows to us is that each arm of government has a role to play in the appointment of justices, in the appointment of such justice of the Supreme Court. What it means also is the Constitution having that opportunity to balance the powers. That is why, as we saw in River State some time ago, and we are now seeing most recently in Cross River States, you will not be able to appoint somebody. A governor cannot on his own be able to appoint somebody that the National Judicial Council has not nominated. It's a nomination. You have a right not you reserve the right to say, well, I have the appointing power, I don't want to obey your nomination, but you cannot go ahead and now nominate somebody and now appoint somebody that the National Judicial Council has not nominated. If you give reasons, if there are good reasons why you would not want to appoint the person, you have to go back to the same National Judicial Council, and then they will commence again the nomination process. And if there are good grounds, they will renominate, or they will stand by whoever they've nominated before. The opportunity is so that we don't sell out our members of the judicial arm of government to the whims and caprices of the other arm of the government. And the Judicial Council also stands to help in the, and I say regulation, I don't want to use it, it is such as, that's what it is, discipline of members of Judicial Arm of Government. So they exist there to be able to check whatever they're doing, and so the correct position of the law still remains that even you will need to be able to remove completely any member. You will need to allow the National Judicial Council, who nominated, to also play a role in looking at such petitions against this judicial officer before that such person is removed. That is where the clear controversy around the suspension of the former Chief Justice of Nigeria still brews, but with way everything was settled, we thank God things were settled in a way that we allow sleeping dogs lie. But the controversy was raging again and again, whether what the president did on the 25th of January 2019 amounts to removal without allowing the National Judicial Council to play a role. What the other side of the opinion holds, that the president only suspended, and that right to suspension lies in the hands of the president, without much allowing the National Judicial Council to finish its own routes. Part of suspension was in relying on the order of the Code of Conduct Tribunal dealing with him as a public officer. So we have these courts in Nigeria, and we have them as courts of record and as public places where we citizens can come and ventilate our grievances. The question that was asked in the previous conversation also came around, okay, so how do we, who hold these people accountable? I would like to contribute a little to that, to say these persons are held accountable by the Constitution, and by extension, they are held accountable by us. What happens if you find any of these judges erring? There is a National Judicial Council that exists to receive your very valid petition or your very valid complaint against these judges, and they will look into it, and they do look into such matters and come up with decisions if they found merits in our petition. A lot of judges have been shown the way out, and a lot of them have been cautioned in order to continue to uphold the greatest integrity of the judiciary. There's a video that is making round about the chief of the American military, and I think he holds to here that they don't take any oath to any tyrant, to even the country. They take oath to the Constitution. And I think it is this Constitution, like Maria have said, the framers, they very well did not leave anything to chance. It is this Constitution, if we can come back, that have found a way to regulate persons, in governments that have had governmental powers. And so nobody was given the constitutional powers to exist and decide like a tyrant. And so the Constitution has its own checks and balances. And it will pay a lot for us to continue to reflect on this conversation, especially the relations between government and government, the legislature, the executive, and the judicial arm of government, again and again, to see that to demythologize the personality behind these organs of government, for us to see that they are really not gods. They are there very much answerable to our Constitution. And wherever we found them wanting, let us at least be able to take that step, as the Constitution has allowed us to make those formal complaints good enough. There are a lot of socioeconomic civil society groups that are ready to take up any of these complaints. This SERAP have been doing a great job in recent past, not allowing any arm of government to go without being checked, whether it has to do with the pensions that are received by by governors and deputy governors who are also serving as ministers or other senators or any other. So a lot of society organization also exists to help us, just in case we feel a little bit impeded by bringing this on our own. And it's nice to also take out the conversation. We cannot continue to be, how will I say, food, like somebody have put it, all this while. No, the Constitution enables those checks and balances. And the important thing is that the more we continue to have this, to show this activism, for want of a better word, the more each member of this government are ahead on their toes, because the important thing is that they are aware of these provisions, but the fault lies in us not being aware that this provision exists, and we're able to hold them accountable wherever they exist. From the highest member of the judicial arm of government to the least arm of government, they are all one way or the other held accountable to the Constitution. The principle of fair hearing, for instance, flows all the way from the Supreme Court down to the area customary courts or alkali courts or the magistrate courts. So there is no arm that is meant to say, well, you know, because I'm so informal, this constitutional responsibility does not apply to me. So I will take a break here and then be able to leave it out for questions, and also allow my colleague to have opportunity to discuss the other conversations that we have for today. Thank you very much, Joyce.
Wow, Nonso, thank you. Very enlightening and a little troubling at the same time. Maybe I missed it. How do we decide who is appointed a judge in the Supreme Court? The Judicial Council is responsible for this.
Yes, they are responsible to. Yes, there is. Yes, it's just like there's an opening, because the Constitution have told us how many justices they will be maximally.
Yeah. Okay.
Imagine right now there are 20. Imagine, let's give a scenario that the president intends to fill up the slot completely, to fill up the remaining single slots. The National Judicial Council, we have to conduct what I can call the interviewing process, the initial phase of the interviewing process. So they will now look at suitable qualified candidates as recommended by the Constitution. They have a requisite number of practice years, and then they have the other qualities that they are looking out for. So they will now nominate.
Like what? Like what? Do we know?
Integrity is key. Integrity is key. That is why there are a lot of check. Integrity is key. Security is key. I don't know whether the security here is the same one that the Cross River State House of Assembly is raising for refusing to complete the process of appointing a chief judge that was nominated by the National Judicial Council for the sole reason that she is by birth from Akwa Ibom State, and therefore they consider it to be a security risk. That's not the kind of security we're talking about here.
So when we say security risk, I never understood that myself. What does that mean?
Yes.
Security risk.
Yes, I think that relies very much. That is why there's opportunity for the Department of State Security Service to play a role in terms of looking at the records. The point really is that for such important position as a judge of a court or a justice of Court of Appeal or Supreme Court or any of the courts that by name justices, you really don't want to nominate somebody or appoint somebody to that position whose whole length of life either in public service or prior to coming to that position you don't know of. And so at every point in time, the appointing authority and the organ considering the nomination, we want to have an opportunity to know a little bit more of all the affiliations that the person has been to. The appointment of a partner of our firm gave a very clear, vivid example of this kind of check, because down to her social media exposure, all these were checked because of the because of the sanctity of the office. Remember, it's not an elective office, okay? So it doesn't really demand on the number of valid votes casted and whether the wasted votes were removed. Therefore, you really and it's also not tenured as such. Retirement is upon attaining the age of retirement. Okay, so that if somebody is appointed, if somebody becomes a judge of Supreme Court at his early 40s, he's going to stay there for so many years until he's 70. Down
exactly
when he will retire. So because of that, you want to make sure that you are entrusting to these people, to persons of such integrity and impeccable character, the duty to uphold the Constitution and to interpret the law.
Thank you. For those who are just joining or who were not here last week or who did not hear when it was said earlier, next Sunday, we're going to have something like an open house discussion where by that time, we would have finished discussing the Constitution. We will start picking some of the lapses and the gaps and how we can move forward as citizens, what we can do, how we can advocate, how we can agitate, what we can do to ensure that the Constitution is adjusted, amended, or completely rewritten. Maria and Sarah, do you have any responses for some of the questions that have come in, or would you want to chip in a thing or two before we allow Sarah to discuss Chapter 8, which is about the Federal Capital Territory and other provisions?
Well, we can say something about Adetomiwa question about why do we have Sharia laws and courts in Nigeria if Nigeria is not a religious federation? Well, I hope my response was satisfactory. Otherwise, I want to defer to you to speak a little bit more about that.
I think you have answered it properly. Maybe it's just to emphasize that you recall our first discussion when we say the reason why state houses of assembly were given the powers to make law, right? And we say this because there are some certain things and issues that are peculiar to each set of people. And of course, the Constitution presumes us to be a secular state, but notwithstanding, it also confers us right to practice any religion we want under Chapter 4. So the fact that you have been conferred the right to practice a religion and the nation is a secular state, it is anticipated there are issues related to the religion you practice that may need some sort of intervention from court. And the only way you can be able to have some sort of such intervention is when there are courts that are established for those purposes. And of course, definitely, just side by side with that, we also have the customary courts that also had to dispense with customary issues, just like the Sharia issues that goes to the Sharia court. So it's just for the purpose of balancing and to ensure that each set of people are there is provision for them to be able to properly ventilate whatever issues they have through the process of the judiciary in whatever locality or whatever setting they will be.
Okay. So for Adetomiwa and others who are watching, listening, either here live or during the replay, it's because the religion of Islam does have its own legal courts. If the religion of Christianity had her own legal courts, the Nigerian constitution would have allowed her to operate, yes?
That's right.
Is that it?
That's it. That's it.
Okay. So Sarah, please, we proceed to Chapter 8. Hey guys, we have come to Chapter 8. Chapter 8, from chapters 1 to 8. We're now in Chapter 8 where we're discussing the Federal Capital Territory and the other provisions. Please help me say thank you to, or join me say thank you to Nonso and Mawia. We go backstage.
All right. We're now in Chapter 8. We're going to be looking at the Federal Capital Territory and other supplementary provisions. Right, so the Federal Capital Territory, as we all know, is the nation's capital. It is the seat of government of the Federation. It is, like we discussed when we talked about state governments, we said that the seat of government of a state government is usually the capital of that state. Whereas the Federal Capital Territory is not stricto sensu a state. It is the provisions that regulate states also applies to it. All lands in the Federal Capital Territory is vested in the president. Like we have state executive, judiciary, and legislature. The same also applies for the Federal Capital Territory. The executive powers is mainly vested in the president. He also he's empowered by the Constitution itself to appoint ministers who will administer, who like be in charge of the affairs of the Federal Capital Territory. The legislative powers with respect to the Federal Capital Territory is vested in the National Assembly. So the National Assembly makes laws for the Federal Capital Territory. The judiciary, of course, the Federal Capital Territory has a high court, like Tonso has just said, also is presided over by the head of the judiciary for the Federal Capital Territory, like in other states, is also the chief judge of the Federal Capital Territory. So basically, that is all there is to know about the Federal Capital Territory. Right, so we now go over to the miscellaneous provisions. If you look at sections 305 of the Constitution, it talks about procedure for declaration of a state of emergency. So yes, I'm talking about sections 305 now, which talks about procedure for declaration of a state of emergency. The president by law is the only authority that can declare or proclaim, make a proclamation for a state of emergency in the federation. Here, a state of emergency is sort of a situation where law and order is put on hold. It's where law and order is being violated, more like a situation where the sovereignty of the nation is being threatened. In situations of crisis, natural disasters, the president can declare a state of emergency, basically just to contain the situation, whatever the crisis, whatever the revolutions, or whatever the disaster is, the president can do that. Now, the governor of a state cannot declare a state of emergency. If for any reason he fears that there's any issue that requires for a state of emergency, then he would request that the president does that. Of course, he must get the requisite approval or support from the House of Assembly of that state, and the president would then, by a written instrument published in the official Gazette of the Federation, declare a state of emergency. When he does that, he'll then transmit that gazette to the president of the Senate, who will also notify the Speaker of the House of Assembly, and then the both houses will convene and deliberate on it to consider whether or not to grant that request. And where it is resolved, a resolution will be passed to that effect, and then the state of emergency proclamation will now be in place. It is very important to note here that the reason for declaring a state of emergency is usually, they say it is for protection of public safety, public order, and public morality, sort of issues that tend to rise up in the nation. I can't remember the year, but President Olusegun Obasanjo, I think in 2003, declared a state of emergency in Plateau State. And of course, the reason he gave was that to maintain public order and all. Even if we know that a lot of times it may be politically motivated, but then this is the reason for a declaration of a state of emergency. Now, if you look at the provisions of sections 305 sub 3, it lists the occurrences that must happen before a state of emergency can be made. And that is where the federation is at war, where there's fear of invasion of the federation, or there's even the perceived fear that there's going to be an invasion. Or, like I said, in issue of disaster, like where we have COVID-19, for instance. Yeah, so there's a question, say, does this section address the things that occurred on 20th 10 2020? Well, yes, these are, I mean, if the government at any time felt like it could no longer, what was happening in the country or in the states, wherever, was threatening the sovereignty of the state or of the nation, the sovereignty of the nation rather, then it would probably be a ground. And then there's chaos, there's lawlessness. It is definitely a ground to declare a state of emergency, even if that was not the route that the government even took in this situation. So yes, I would think that it is covered where the government, where order cannot, where it is impossible to maintain order, then the president would be, empowered to declare a state of emergency for the federation or for any state, like I have already said, on the request of the governor of that state. Right, so I was talking about certain things that must happen. If you look at sections 305 sub 3, it is listed here where the federation is at war, where there's imminent danger of invasion of the federation or involvement in a state of war, where there's actual breakdown of law, of public order and public safety in the federation, where there's a clear and, like I said, the danger does not necessarily have to happen. If there's a perceived, or it is clear that there's going to be a breakdown of law and order, then the president is empowered to declare a state of emergency. Here. Sorry, give me a minute.
Let me bring Mawia and also up. We just lost Sarah to network issues or a network glitch for now. So, question for both of you. When the state of emergency or a state of emergency is declared, what is the intervention strategy? What's to happen?
Okay, the very visible thing that we see is that for us to understand that the government declaring curfew either for reasons of COVID-19 or for reasons of NSAS, it's not the same as state of emergency. Yeah, state of emergency, once it's declared, it has a way of suspending the powers of whoever is the chief executive officer of that state.
Okay,
the
powers are
president do appoint somebody that had. Yes, if state of emergency was declared because now no longer hold the position of executive, have executive power for within that period, an administrator will be appointed for that period of time, with setting committees to decide. So that executive power is suspended, legislative power also suspended, but judicial powers preserved. You see how the court is not missed in the RALF. So that is one of the visible things that you see. And so so it's also construed strictly, the instrument of that declaration, so that people will not use the opportunity of state of emergency declaration and start doing whatever they like and turn the whole state into a clear era of anarchy, because things have gone out of hand that the state of emergency was declared. So the aim would be strictly to restore back normalcy to the state. So that is the main aim of whoever that is charged with that instrument of state of emergency. So this is one of the visible things that we can see. While we are able to speak on any other one that's also like.
Sarah is back for now, so let her continue. When we're done, I'm sure we'll all come back for some more discussions before
All
we
right.
start. All right, Sarah,
All right.
please go ahead. Rest of us are going back.
All right, thank you. Okay. Yeah, sorry about that network issues. Okay. So I would like to go back to when we're talking about fundamental rights as contained in chapter 4, and when also talked about derogation of that right in sections 45 of the Constitution. I mean, a state of emergency is one of the times when basic some fundamental rights, can be derogated from. Although this doesn't necessarily apply to your basic right, like your right to life and all. But in times of where there's a declaration of a state of emergency, I mean, because the government tends to bring in some form of a military presence, to try to contain whatever crisis is going on in the nation. So a lot of times we find that fundamental rights are being derogated from. Right. So that's that. And then, well, I would also like to also point out quickly here that, I mean, the law is clear mostly that where the law provides for the procedure to do a particular thing, doing it any other way negates the provision of the Constitution, and then it will render such acts that have been done unconstitutional, except of course the process of complying with the law is duly followed. I mean, this is also one of the issues, the brewing issues that came up during, I think, Goodluck Jonathan's time, when he declared a state of emergency by a national broadcast. The issues that came up were like, well, yes, he's trying to maintain order, but has he followed the process of law? Has he complied with the provision of the Constitution with regards to declaration of a state of emergency? At the time that he made that broadcast, he had not he had not published in the official gazette. He had not transmitted to the Senate president and or whatnot. But then I think he took the time to try to comply, and then we can say that that declaration was proper, having complied with the provisions of the Constitution. We're also going to talk about resignation. That is provided for in sections 306 of the Constitution. So any elected or appointed, any person who is elected or appointed into public office can resign. It is not a till death do us part affair. You can resign, and your resignation will take effect when you submit your the resignation. The resignation must be in writing, and it will come into effect once you submit it to the proper authorities. So for the president, for instance, if the president wants to resign, he would transmit his intention to resign to the Senate president. If the vice president wants to resign from office as vice president, he would notify the president. If the governor wants to resign, he would notify the Speaker of the House of Assembly. If the deputy governor wants to resign, he would notify if the deputy governor wants to resign, he would notify the governor. If the it goes like that. If a member of the House of if a member of the House of Assembly wants to resign, he will notify the Speaker. If a member of the National Assembly in the respective house wants to resign, they will also notify their heads, and that is the way that works. We're now going to look at Section 307 of the Constitution, which talks about restriction on certain citizens of Nigeria. So that section basically provides that a person who becomes a citizen of Nigeria by registration or by virtue of a grant of a certificate of naturalization shall not sorry, what's going on? Hello, can you hear me?
Yes, Sarah, we can hear you loud and clear. We can see you as well. For some reason,
Okay.
yes, you went
Yes,
sideways.
I'm back.
You're back.
Yes. Okay, thank you. Okay, so yeah, the point I was making here is that any person who becomes a citizen of Nigeria by either registration or by grant of a certificate of naturalization is not, cannot hold any elective position for a period of at least 10 years. Yes, so if you're a citizen of Nigeria by virtue of registration, like also dealt extensively with citizenship in Chapter 3 of the Constitution, you cannot hold elective positions, and you can also not be appointed. You can also not be appointed into public service, right? We're now also going to look at sections 308 of the Constitution. Restriction on, well, the same for people who, for citizens rather, who became citizens of Nigeria by virtue of registration or by grant of a certificate of naturalization. They are restricted from, they are protected from certain proceedings, criminal proceedings or civil proceedings, as the case may be. Right, so we're now going to part 3 of the sections 8, which provides for citizenship. Now, sections 309 basically provides for citizenship, and it says that notwithstanding the provisions of Chapter 3, that's citizenship now, of this Constitution, but subject to sections 28 thereof, any person who became a citizen of Nigeria by registration under any constitution. I mean, if you're a citizen of Nigeria by birth, by registration, by naturalization, under any constitution, shall continue to remain a citizen of Nigeria under this present constitution. So the fact that they said there was a night you became a citizen by registration under the 1979 constitution, for instance, under this present constitution, you are still a citizen of Nigeria. We're now going to look at staff of the Okay, so some Onyeka Erebu is asking, is appointment into public service also subject to the 10-year clause? Yes. Like I said, you cannot be elected or appointed into the public service. So if you became a citizen of Nigeria by virtue of registration or naturalization, then you must have been a citizen for at least 10 years to be able to hold an elective or an appointed position. Yes. So I can proceed. Thank you. So staff of the sections 310 provides for staff of the legislative houses, like we discussed last week, that the National Assembly and the State House of Assembly will both have clerks, and by virtue of the Constitution, the National Assembly by its act would ordinarily, appoint a clerk for itself. But then, if you read through the Constitution, where they are not able to, or until they do so, the Federal Civil Service Commission shall be empowered to appoint, of course, with due consultation from the President of the Senate or the Speaker of the House of Assembly, as the case may be, or as regards the State Legislative House, the State Civil Service Commission is empowered to appoint a clerk, of course, with due consultation from the Speaker of the House of Assembly. Right. So here, sections 311 says standing order. So basically, when we discussed last week, we said that the National Assembly has they are empowered by law to make rules, or to make rules and regulations, or to make laws to guide their activities, their sittings, their proceedings, and all. But when they fail to, or not when they fail to, if for any reason they have not done so, then the provision of the Constitution will guide them, and will be like the standing order now. Yes, so basically, I think that if we now go through to part 5 of the Constitution, this is part 4 rather of sections 8 now. It is the interpretation section. So when you read the Constitution, for instance, and then certain words like when Maria made mention of school sat as to what the meaning was or what the contemplation of the Constitution was when it said school sat. If you go through the interpretation section of the Constitution, you would see the real intention of the words when they are used in the Constitution. You see the intention of the draftsman, what it applies to and what it doesn't apply to. Of course, the law is clear that the express mention of one thing excludes others not mentioned. So when you look at the interpretation section in analyzing the provisions of the Constitution, you'll be able to curtail it to what the Constitution prescribes, to what the Constitution applies to, and then what it doesn't. Right. So if we go through all of that to the end, we can say that we have conclusively studied the Constitution down to when you go further, what you now have are the various schedules that we have been mentioning as we, as in the course of this series. And also basically that I think I skipped something. Yes, I skipped immunity. Yes, sorry, I skipped immunity. So under the Constitution, certain persons are protected from, courts, from being prosecuted, from instituting a criminal or civil matter or criminal matter during their term in office. And these persons are the president, the vice president, the governor, and his deputy. I mean, a lot of persons have come up to say, oh, why does this not extend to the legislators? Why does it not extend to the heads of the legislative houses? But then, again, other people have also said that, giving our leaders, giving the president or the governor any form of immunity whatsoever, does it not impede on the principle of accountability? I mean, if they know that for the period I am holding office, I can do anything, I get away with it, and you cannot take me to court, you can't institute any action against me, although other persons have also argued that what the law seeks to protect is the office, so that we don't drag our leaders, we don't drag our presidents to court and then subject them to cross-examination and all the rigors of litigation and all whatnot. However, there are certain exceptions, like we saw in the state of the former governor of Bayelsa State, where he was charged for an offense in another state, even when he was still a sitting governor in Nigeria, in Bayelsa State here. I mean, so for acts done outside the country, you can be charged and prosecuted. For purposes of investigations, I mean, this doesn't, as long as the investigation does not, it will not get to the point of questioning or arrest or detaining the office holder, then you can just go ahead with your investigation and keep it until they have served full term. Then you can go against them. Yeah, so that is basically what I think I skipped, and it is important for us to go there and talk about it. So thank you so much, everyone, for your time, and then we're available to take any questions as they come.
Thank you, Sarah, my special somebody, our special somebody. Thank you so much. Thank you for everyone who is watching on YouTube, on Facebook. And if you're watching the replay, it's okay to put your hands together right now, physically or electronically, to say thank you to Sarah, to Nonso, and to Maria. It's been 4 solid weeks of us gathering together to discuss the Constitution, and we were doing it line by line, as it were. We went chapter by chapter, section by section, sometimes touching on subsections and paragraphs in detail. And of course, once in a while, we summarized some sections and subsections so that we all have a clear idea Well done. Thank you so much. So next week, before we take questions now, please everyone, next week we're going to have an open house discussion. We will be discussing the flaws, the gaps in the Nigerian constitution. What is the way forward? For example, how do we completely expunge the immunity clause? Why? Because I mean, it's always been a bone of contention. It's always been, there was a certain governor in River State who, at that time, we felt he should have been prosecuted for so many reasons, but he went away scot-free because of the immunity clause and was never, ever, ever subjected to any form of accountability by the same people who elected him into office. So we need to know what the way forward is. I'm not asking any of you, Sarah, Maria, or Nonso, to be put on the spot to say what's the way forward, but if you have some contributions to make concerning especially the immunity clause, please feel free to unmute yourself and say something to us. People are saying thank you in the comments. We're expecting questions, guys. If you have questions, please feel free to drop a question in the comment section. We have about 23 minutes.
To add, can you hear me? Maybe just to add on what Sarah said on the immunity. The fact that they are immune from being prosecuted for any civil or criminal matters or criminal case.
Can you make it a bit louder, Maria?
Can you hear me?
It's not very clear. It's not as clear as it was before.
Okay, what about now?
Okay, go ahead. Well, go ahead. We'll make it work.
I was saying, in addition to what Sarah said earlier, the fact that those executive members are immune from any form of prosecution for civil or criminal matters, they are not immune from being investigated for those criminal offenses or civil matters, right? So during the tenure of office of those executive members, they can be investigated by the law enforcement agencies, and if they are found or established to have committed any offense, then the prosecution can wait after the time of office, then they will be prosecuted for the purpose. So the essence is to ensure that evidence are not destroyed before the time of office, so that evidences can be preserved, and after the time of office, they can be prosecuted for whatever wrong they have done. So just to add that. I don't know if you get me.
Now, so would you like to add any comment to that? Yes, very clear. They can be investigated after they've left office, and regular judicial processes can be activated. Nonso?
Yes, I agree. I agree completely with Muawiyah. Also, I also want us to keep in mind that the fact that that immunity exists while they are in office does not mean they are now very much above the law. And I think some of those infractions that we think, oh, we don't have any remedy because they are immune, may also be grounds at which we can seek the services of our legislature, whether it's the State House of Assembly or the National Assembly, if it's the president, to commence impeachment proceedings if there are such gross violations of provisions of the Constitution. So it doesn't make them completely go scot-free. Because the philosophy behind it is to sort of protect them from, how will I put it, from numerous litigation, because it may sound a little bit distracting from their office, from what's in discharging their powers and in carrying out their public duties, which, as you can see in the Constitution, are enormous. But in the event that they want to use that as an opportunity to go and commit all sorts of infraction, it may ground their impeachments. That's my recommendation.
Thank you very much. I don't see any question. I'm seeing, yay, thank you. I don't see any questions. So it is safe to assume we have no questions. It means we have understood clearly. We're going to chew on this. I will send the link to as many of us as I have on my WhatsApp group. I'll put it up on my social media pages. Please, I would ask you to share with your friends, your family. Tell them to watch these series. And I would send the invites out early enough by the grace of God. I'll send the invites out early enough for the next week's open house session. We will announce the lawyers who will be here. But before we go, there was a comment I dropped in the comment section, just, by way of, it's not a question, it was just an observation that everything in the Constitution is a he, every gender referred to, every role. Is that the reason why we've not yet been able to have a female governor or female president? In fact, jokingly, or as it were, informally and jokingly, some people were saying recently or during the NSAS protest, they started creating flyers of possible governors, presidents and vice presidents. And in no flyer did I see anybody casually say, oh, Aisha Yesufu could be our next president. It was always Aisha Yesufu as vice president to, there was some other men, So I was like, the Constitution here is always saying he. Perhaps that's why the gender balance or the gender equity bill was not able to pass through the House. Perhaps that's why the Senate quashed it, because the Constitution makes the provision for a she. Well, we'll discuss that during the open house. It's not, this is not about questioning what is in the Constitution. For me, this is a comment for going forward. Someone says here, John Owerman says, many thanks for this platform of enlightenment to improve our knowledge in our Constitution and rights as citizens. I am encouraged. Thank you, John. Onyeka says, someone asked this question earlier, but I do not recall it being answered. Regarding the declaration of assets and liabilities, does this extend to foreign assets and liabilities?
It does. Every asset that you have before you occupy that office, for wherever it will be, anywhere in the world, you have a duty to declare it.
Yes. Okay. Thank you. Yes. Onyeka, thank you for bringing that question back. We have duty to declare. Perhaps one of the reasons why people do not declare assets, perhaps, is because they don't know they don't have any document analyzing all assets. And because they also know nobody is going to hold them accountable to it, they don't bother. I was having a conversation with a very interesting gentleman earlier today, and he said, oh, he would like to see some of my financial reports for this year so we can ascertain where my business is planned for next year. It occurred to me that I do have all my financial reports for this year because thankfully I have an accounting company called Kobo Accountants who work on all my accounting books. But then it left me thinking, how many other individuals can produce documents for themselves and their organizations up to date every year? We'll leave this for the open house. Perhaps that's one of the reasons why we do not have people declare assets. Is it possible? Is it possible that that's one of the reasons?
It may be.
Because we've seen situations where overnight, as it were, somebody was declared a commissioner of a state, commissioner of something. The person, we've seen live situations where someone is in his house or her house, going about their normal business, and then somebody calls to say, congratulations, we hear you've just been appointed commissioner for, and it's like, me? How? Where? Nobody. So, have you ever heard of such a situation before?
Mm-hmm.
Yes, so, I think it does happen.
Yes, so I'm now asking, where was the time? Is it possible that those are the reasons why sometimes they just overlook this and say, don't worry, she's qualified, he's qualified, bring them in. And we don't go into the nitty-gritty details of declaration of assets and things like that. But then again, it just shows us some of the faults.
But again, there is some sort of, those things contribute. But then there is some sort of negligence on the part of those people, and at the same time taking things really for granted. Because the process has a kind of a grace period. Now, even if, let's say, the Code of Conduct Bureau found that you didn't declare ABC asset, right? They have a process where they give you the grace period to declare the asset and fill the form. It is only when you do not declare after the grace period that you will be able to face the consequences. So, and you see people occupy those offices for 4, 3, 5 years. The grace period will be there for them. They will still not take the advantage of it. So it's just really negligence on our part and taking things for granted, a lot of us.
grace period, negligence, and taking things for granted. Thank you. If you want to stand for office, you know you're expected to declare your assets. Yes, Nene, we know, but because the accountability system has been neglected, many people do not bother. Well, this and many more are the things that we need to change in the new Nigeria that is being birthed, and we all are part of this birthing and this accountability setting that we want to make sure is put in place. So we want to say a big thank you to these fine lawyers from Primera Africa Legal, one of Africa's finest law firms. Thank you so much for your time. Sarah Uku, God bless you. Nonson Kamuke, thank you. Our Mozart. And Chairman Mao, Mawiya Yunusa, thank you. We hope that when we call on you again, you will heed our call and be glad to grace this platform and many more. Thank you. Thank you. Our sincere thanks to the partners and other colleagues at PAL. We will do well to, please do well to extend our thanks to them all. Allow me mention, please, that it was sad to hear that one of the partners at PAL, Boma Labi, lost her husband several days ago. And so we mourn with her. Our condolences go out to her. May God strengthen and soothe her. And then a few days ago, her name was mentioned as though shortlisted for the new Senior Advocate of Nigeria. So I sent her a message saying, is it okay for us to say congratulations amidst condolences? And I said, the answer is an emphatic yes, because should your husband have been alive, he would have been proud to see you shatter this ceiling and many more to come. So our congratulations also go to Boma Labi on this new height that she has so worked hard for and definitely deserves. Thank you all for being here. Thank you to Primera Africa Legal.
Thank you very much.
Everyone who has stayed, who has watched on YouTube, on Facebook, and who is watching the replay right now, thank you. Spread the word. The new Nigeria is being born, and is being born by we, the people of the Federal Republic of Nigeria. Bye-bye, everybody. Thank you. God bless.
Bye-bye.
Bye-bye, everyone.